So let's just review. We talked about powers of the federal system. We explained that express powers are those that are specifically given to the federal government. The bulk of those are found in Article 1, Section 8. We also find implied powers there through the necessary and proper clause that says that you can make any laws that are necessary to make sure that you can carry out the powers that are expressed. Article 1, Section 10 tells the things that states cannot do or prohibited from doing. Coin money, create titles of nobility, start a war, enter into compacts with other states without permission. Article 4 outlines the things that states must do. There's where we find the full faith and credit clause. You have to acknowledge the laws of other states and acts of other states. And you must give the privileges and immunities of citizens of your state to all the other people. You can't tell people from South Carolina that they can't drive through Texas or can't buy property in Texas. Then we looked at Article 10, the 10th Amendment, that specifically says if it hasn't been delegated to the federal government or it hasn't been prohibited, then it is a state power. We looked at the chart that explains powers that are delegated to the federal government, powers that are reserved because they're not mentioned. If it's not mentioned at all, then it's a state power. And then we talked about concurrent powers, powers that both state and federal and lower levels of governments have. One of the powers that was listed in Article 1, Section 8 just gave the power to regulate commerce between the states, with other nations, and with Indian tribes. And so we call that regulating commerce, interstate commerce and international commerce. We call that the Commerce Clause. And if you have ever heard someone say that Congress has the power of the purse, that means that they get to allocate money and they get to regulate how and where it can be spent. So over the years, there have been plenty of conflicts where states were telling federal government, you can't do that. Federal government was coming in and saying, Article 6, Supremacy Clause, yes, we can. One of the most famous cases that looked at this conflict between, can the federal government do that? Isn't this a reserved power? Is the McCulloch versus Maryland case. McCulloch versus Maryland is a lawsuit between the state of Maryland, treasurer of the state of Maryland, and the president of the Second Bank of the United States. Second Bank of the United States was placed in Maryland, in the state of Maryland, and it was the first fully functioning national bank. Up until then, banks were all state, and banks made money by lending people money and charging interest, by investing the money that they held for people. They were a way to generate revenue, and they paid taxes to the states. So when the national government decided that it was going to try to put a bank in Maryland, the state of Maryland was a little upset because they weren't getting any taxes. They weren't getting any of the benefits of this revenue that was being generated. All that revenue was going to the federal government. So they sent the Second National Bank a tax bill. They said, states, banks in Maryland pay taxes, and you are a bank in Maryland, so you need to pay us taxes like other banks. And after looking at Article 1, Section 8, I don't see anywhere in those 17 expressed or delegated powers that it says the power to create a bank. Think that you are violating the reserve clause, because banks should be a state power. So this was the argument that made it to the Supreme Court. Now, this case made it to the Supreme Court. So we are about to get an edict, a decision from the Supreme Court that decides what's constitutional. This is how it works in the United States. So once this case made it to the United States Supreme Court, and it was the Supreme Court at the time had a Federalist Chief Justice, a guy named John Marshall, and there were Federalists. They had a Federalist majority on the Supreme Court. I think there were 5 of them at that time. Basically looked at the Constitution and had to make a decision about whether or not a national bank was going to have to pay state taxes, and whether or not Congress even had the ability or authority to establish a bank in the first place. So what they decided was, though banks were not in the enumerated powers, the necessary and proper clause said that they could regulate commerce. And they decided that a bank generating revenue was commerce. And so through the necessary and proper clause, it says you can pass any laws to make sure that the powers that are enumerated go into effect. So using the necessary and proper clause and saying that their authorization was the Commerce Clause, they said that there was nothing wrong with the national bank. And looking at the Supremacy Clause, they said that the laws of the United States shall be the supreme law of the land. And so states did not have the authority to send a tax bill or have the national government pay to states which were subordinate, because of the Supremacy Clause, the Article 6. So this really expanded federal power, because as far as the federal government was concerned, the Congress was concerned, the easiest thing to do to justify whatever law you were passing was, well, this is commerce. This is commerce. We're regulating commerce. And for years, that's exactly what Congress did. Anytime that they were not exactly sure about their authority, they would say, well, we're regulating commerce. We're regulating commerce. There was a case called United States versus Lopez, 1995 case. And in this case, the United States Congress had passed a law that said that you could not be within 100 feet of a school with a firearm. And they argued that the sale of firearms was commerce, so therefore they had the ability to regulate where these items could be carried through the Commerce Clause. Now, this was one instance where Supreme Court took the side of states and said, I'm sorry, federal government, that has nothing to do with commerce. Deciding where someone can carry a firearm is an important issue, but it is not regulating commerce. But for years, that was the easiest thing for the federal government to do, was to slap that regulating commerce label on laws as the authority for whatever they wanted to do. So at some point, this power of regulating commerce, began to be abused. So the United States Constitution was finally finished in 1789, finished being ratified 1791, and the amendments were the Bill of Rights were ratified somewhere around that time as well. And really the view of the way government should work is, yes, federal government has very specific things that they can do. Those are enumerated powers. But those are all the powers that they have. And really, the federal government needs to concentrate on those things, making commerce easier, making roads easier, making post offices easier so that we can get our goods from state to state, making canals, anything that would make one of their powers work. So they were to look at interstate and international. And really that was it. State governments had the responsibility of everything else. And so they had to raise the funds, they had to collect the taxes, they had to decide the laws, they had the police power, they were in charge of schools, they were in charge of their poor, they were in charge of generating enough revenue to take care of their citizens, while the federal government kind of flitted around and took care of interstate and international issues. And state governments were very quick to let the federal government know that they thought that they were out of their lane. And so there was constant conflict. I gave you an example of one where we looked at the Marbury versus Madison case. In that instance, the federal government prevailed, but in many instances, state governments prevailed. And the Supreme Court over and over again were like, well, it's not in the Constitution, it's a state power. It's not in the Constitution, it's a state power. So this was from the late 1700s, really up until the 1930s. That was the way that everything worked. But a couple of things happened. In around 1913, the states ratified the 17th Amendment, and the 17th Amendment gave the federal government the ability to collect income tax. Now, why states agreed to allow the federal government to collect income tax, I'm not sure. They certainly had the power to tax, but they did not have the power to do it and to have an income tax until the states ratified the 17th Amendment. So federal government was financially collecting a lot of money, but not spending a lot of money. They didn't have a whole bunch of responsibilities. Most of the responsibilities were those of the state. Then, 1929, the stock market crashed and had a series of natural disasters, and it all arrived at this financial calamity. There were other calamities, but we're talking about the financial calamity that led to what we call the Great Depression. Businesses closed. If businesses closed, people didn't have any jobs, so they didn't have any money. People were not buying goods because they didn't have any money. People were losing their houses because they didn't have any money. Even the middle class and upper middle class lost their money because the money that they had invested in the stock market was essentially gone. the money that they had put in banks were closing because people were defaulting on loans, and they also gained revenue from investments. All of that was out of the window. People were trying to get their money out of banks, and banks are like, we don't have it. Literally, we invested your money while you weren't looking in the stock market, and now we've lost our shirts and we don't have your money to give you. So state governments weren't really able to collect sales taxes. Local governments really weren't able to collect property taxes because people weren't owning property. People were not buying goods. Um, and so state governments were in a bad way. Who had some money? Federal government had some money because they had been collecting personal income tax for years, for more than a decade. And the United States citizens, through the Electoral College, elected a guy named Franklin Delano Roosevelt. We'll call him FDR for short. F as in Frank, D as in David, R as in rabbit. FDR. And he had this idea. And his idea was, why don't we let the national government start using some of their money to help states? And let's put this in perspective. Let's say that you are 16-year-old. You have a job. You have a car that was purchased by your mom. You live in your mom's house, but you have a driver's license and a job. If you come and tell your mom or dad or parents, let's say you live in Texas. I think I'm going to drive to California. What are your parents going to say? They're probably going to say, no, you're not going. You're not taking the car that I purchased for you. You are not leaving the house where I can give you protection to go and do what you want to do. And as long as you live in my house, I get to make the rules. Yes? I'm just going to assume you're saying yes. So, really, literally, let's think about what happened when the federal government had all this money and they decided that they were going to distribute it to state governments so that state governments could take care of their people. There was a definite shift in power. And the federal government started telling state governments, and in some instances, even local governments, we'll be happy to give you this money, but you're going to have to follow our rules. You can distribute this money to your people. You can distribute food, to your people, but you're going to have to agree that you, won't discriminate. You got to clean your room. You got to make sure that you're in by curfew. They made rules. We call this period of time cooperative federalism, where states were doing a lot of the work, but the federal government was providing money and rules. So think about if you lose your job, you are going to go to a state-run office called the Office of Unemployment. Where do they get the funds that they distribute to you? Some of it comes from states. Some of it comes from the federal government. There are all kinds of rules that dictate who and how much you can get, and those rules are made by the federal government, because the federal government is supplying most of the money for that program. So they're working together, and again, we call that cooperative federalism. It replaced cooperative federalism. So under our scenario where because you make the rules, you get to make the decisions, we call really the best way to look at that is grants. Now, the way that you get a grant, if you decide that you want some money from a governmental entity, you have to fill out an application. You have to show that you qualify. You have to agree to certain rules, and then you have to follow up and show that you followed the rules. So a grant in aid is money that is given by the federal government. The New Deal provided many programs where the federal government was delivering money directly to states. A categorical grant, so grants and aids are where they're giving money. A categorical grant is one where there are lots of rules. Federal government says you can have this money if you promise that you will not discriminate when you distribute this money. And so you have to come to the federal government and say, we'd really like to have this money. We promise that we won't discriminate. We will put programs in place to make sure that that doesn't happen. And we will put some skin in the game and donate X amount of percentage of the money that is needed from our own state coffers. Now, there is another choice, and that is called a block grant. So categorical grant is hoops that you have to jump through. A block grant is one that basically says, here's some money for your department. You get to make the rules. You get to decide how it's going to be distributed. You get to decide who gets it. We're just going to give you the money. And really all that we want you to do is show us that you spent the money in the department where the money was granted. States love block grants. You know who was one of the most prolific block grant proponent? That was Richard Nixon. Richard Nixon was a states' rights guy. And he really believed that states should be able to spend the money where they needed it without the federal government looking over their shoulder. And so there were many block grants under the Nixon administration. Another big proponent of block grants was Ronald Reagan, another Republican president. When a federal government or when an upper level of government gives a lot of discretion to decide to state governments, that is called devolution, where they're pushing some of the responsibility down to states. That is called devolution. So over the years, there have been many conflicts between states and states wanting to do what they wanted to do and federal government imposing its will on state governments. Some examples. Many states wanted to have segregation laws. For years, the federal government said you can't do that. Then the federal government through the Supreme Court said, well, if you really want to, you can. In the Plessy versus Ferguson case, a gentleman filed suit against the city of New Orleans because they had segregated cars on their trains. And they said this is a violation of the Equal Protection Clause of the 14th Amendment. And the federal government said all that it says in the 14th Amendment is that things have to be equal. It doesn't say that they can't be separate. So state governments, if you want to have segregated facilities, go ahead. Those laws we often call Jim Crow laws, and they were much more prevalent in the South, although there were some states that had segregation laws, some northern states that had segregation laws. One example is Topeka, Kansas. Remember in chapter 1 when we were talking about the fight for equal rights, we talked a little bit about the Brown versus Board of Education of Topeka, Kansas. Kansas is a northern state. They had Jim Crow laws and segregated schools. Here, the Supreme Court jumped in and said, nope, you're going to have to desegregate. Whether you want to or not, you're going to have to desegregate. Another place where the federal government jumped in and said, we know that you get to establish voting and voting rules, but you're going to have to find a way to do so in a non-discriminatory way. You're going to have to find a way to do so in a non-discriminatory way. And that was through the passage of the Voting Rights Act of 1965. Lyndon Baines Johnson, who was from Texas, was president of the United States. And after John Lewis and Martin Luther King Jr., Dr. Martin Luther King Jr., and several others were beaten on the Edmund Pettus Bridge in Alabama, Lyndon Baines Johnson decided that they were going to have to intervene and tell state governments, as far as voting is concerned, there are some things that you just can't do. You cannot discriminate, and we're going to be watching you. And that was through the Voting Rights Act. You cannot tell people that they have to take literacy tests. And anytime that you redistrict or do anything that affects voting, if you are on our bad list because you have been systematically discriminating, then you're going to have your law reviewed by the federal government before you can impose it. Now, recently, Supreme Court in 2015, Shelby County versus Holder, said until the federal government, United States Congress, comes up with a better way to determine who's supposed to be on the bad list, we're not going to require you to have pre-clearance. So they cut it out, and immediately states started to do very suspect things and pass very suspect laws. And now you can't have the federal government look over your shoulder and say, you can't do that. You have to file suit and make your way through the court system before the federal government will go, well, yeah, that's discriminatory. And the Supreme Court, United States Supreme Court right now is very reluctant. They just stay out of voting stuff. So there has been a move to reinstate Voting Rights Act recently. Very recently, in fact, the move to do so has been called the John Lewis Voting Rights Act. So we are really kind of back to a place where federal governments and state governments are kind of at each other's throats, trying to figure out who has the power. State governments now are not saying we don't want your money. They're saying we want your money, but we want it in a block grant and we want it without strings attached. So many states say that what the federal government has tried to do is coercive. And so there we get the word coercive federalism, where the national government tells states that they have to do something. Real good example, Affordable Care Act, Obamacare. There were provisions that said that you had to expand your Medicaid and make more people eligible for Medicaid so that you could have more people covered. Federal government offered to give a lot of money to states to help them expand Medicaid so that people that were right above the poverty line would be able to get to qualify for Medicaid or health insurance. States like Texas were like, no, we don't want to have to pay a penalty because we're not doing something that you want us to do. And they filed suit and won. So now, of course, Texas is one of the states that has the largest number of uninsured people because they did not expand their Medicaid. They did not accept that money from the federal government. So you still have to income qualify, and the qualifications are pretty low to actually qualify for Medicaid, federally paid or insurance. Environmental regulations are another, where the EPA is telling state governments you can't build here because there's some rare bird here, or you can't build here. Recently, the Trump administration has rolled back a lot of environmental policies, including some on oil companies. You don't have to meet certain emission standards. They roll back emission standards and requirements on vehicles. And I told y'all about the Shelby County case. For the most part, we have seen state governments remove polling places, put in voter ID laws so that you have to have an ID that you paid for to be able to be eligible to vote. We have seen all kinds of laws be put in place that technically are taking away some voting rights. But the federal government is not leaning in and saying, yeah, you can't do that. Like in 2011, federal government told Texas that they could not require IDs for people to be able to vote. And so they were not able to enforce the law even though it had just been passed. In the 2012 election, Texas was not able to enforce their voter ID law. But then in 2015, the Shelby County case came down, and Texas immediately put voter ID back in place. And then they were sued. And finally, Texas decided, okay, you can vote without an ID, but you have to fill out an affidavit explaining why you don't have your ID. And if we find out that you did not tell the truth on the affidavit, you can go to jail. So that is where Texas landed after the lawsuits. So Texas gets a lot of money. We don't like to talk about it. We don't like to admit it. But we get a lot of money from the federal government. And actually, the money that we get from the federal government is the second largest source of revenue for the state. The first being sales tax. And Texas's need for money, it grows because we have a population that is getting larger and larger. We have a large number of low-income people in our population, and we have a rise in the number of seniors who arguably need more services. And a lot of time the payment for those services comes from the federal government. So Texas is very dependent on the federal government for money through grants to help their citizens. Really, at this point, states don't know how to operate without that money from federal governments. So this chart looks at the percentage of revenue from the federal government. If you look in 2008, that was the first year of Barack Obama's administration, and the number went way up. We were in the middle of a recession, and the federal government helped many industries and many people, and really increased the amount of money that was given, in this instance to Texas. Then you see that there was a sharp decrease. And we now, in 2019, the amount of money, that percentage of money from the federal government is lower than it was in the middle of the Great Recession, we call it, in 2008, 2009, even 2010. But still, the state of Texas gets millions of dollars from the federal government. Then we have to talk just shortly about some indirect benefits. So this is not money that the federal government is sending to states, but this is locations that are located within states, and then those military installations put people in place that are getting steady income. They buy houses, they spend money, they create the schools, they supply people and keep businesses running in the areas where they are. And there are lots of bases in Texas. There's a Joint base here in Fort Worth. Of course, there's Fort Hood down below Temple. There's a base in El Paso, Fort Bliss. Now my dad was in the Army, and so I have a tendency to know the Army bases better than the Air Force and Navy bases, the names of those, but there are several. The bases provide jobs. Several civilians work on bases. And again, the people that are there, either they do a lot of spending in the community. Even though there's commissary and PX on base, a lot of times they will venture out into the community and buy cars, buy houses, because they don't want to live on base. Let's talk a little bit about unfunded mandates. Let's just look at that word. Let's analyze the word. Unfunded means no money. Mandate means you are being required to do something. Do states like being required to do something but not being given the money to do it? No. States do not like unfunded mandates. A couple of examples. The Americans with Disabilities Act said that you have to retrofit your buildings so that people that are not able, that have mobility issues, can get into your building. People that cannot see or have sight issues can get around your building. People that cannot hear can make their way through the building safely. All these things you have to add: elevators, ramps, wider stalls and bathrooms. All these things you have to add but we're not going to give you any money to do it. You find the money in your own budgets to do it. And if you don't do it, if you're not compliant, then you will have a fine. That is a good example of an unfunded mandate. Many of you may be familiar with the Hazelwood Act. Hazelwood is a state of Texas specific program for veterans that allows veterans to get up to 121 hours of education in state institutions for free. Well, the state of Texas decided that they were going to allow the children of veterans who had not used their 120 hours to use their parents' Hazelwood money. It's called the Hazelwood Legacy Act. So now you have substantially increased the pool of students that state schools have to give free education to. But at first, the state of Texas did not give University of Texas, Texas A&M, Texas Tech, even Tarrant County College any extra money. They just said, you got to give them 120 hours, up to 120 hours of free education. Figure out how you're going to do it. So all these raised expenses and all these hordes of people that are now eligible for free education and no money from the state. Eventually, the state of Texas started to supply some money, not all of the money, to start covering those students that qualified for Hazelwood. But it was a big contention. States don't like for the federal government to do it to them, but they often do it to lower levels of government. And that is one example of an unfunded mandate. We talked about the Affordable Care Act. We talked about some of the issues that Texas had with the Affordable Care Act. The Affordable Care Act has been held to be constitutional, except for that one provision. But now there are several challenges to it. So we will see if it hangs on or not. We talked about the fact that Texas opted out of expanding qualifications for Medicaid so that they could cover more people. And finally, there has been a lot of conflict between states and federal government over the issue of abortion rights. In chapter 1, we talked about Roe versus Wade. And the fact that states cannot pass laws prohibiting abortion, banning abortion. There was a later case. It was called Planned Parenthood versus Casey, 1992, where the Supreme Court said, okay, you still can't ban abortion, but if you have laws that are restrictive or make it more difficult to get abortions, that's fine, as long as they are not an undue burden. Planned Parenthood versus Casey gave us this new test. You can't ban abortion, and you can't have laws that are an undue burden. In 2006, the state of Texas had passed a series of laws that restricted abortion and access to abortion. And Whole Woman's Health filed suit against the health secretary of the state of Texas, Mr. Hellerstedt, and the state of Texas was found to have some laws that were indeed an undue burden. So, and the name of the law that Texas passed was House Bill 2, HB 2. So sometimes and I hope that you are clear that the final arbiter on what will and won't work and what's constitutional and what's not is the Supreme Court. We talked at the beginning about marijuana legalization. Now, as of the date of the printing of this book, 31 states allowed medical marijuana. I think that it may be more now. And about 10 states, including California, Alaska, I know, Colorado, we definitely know, New York, Washington, D.C. is not a state, but are among the states that allow. Nevada, I know for sure, allow recreational use of marijuana. You can walk into a dispensary and walk out with as much cannabis as you can tolerate. But this debate about marijuana use and legalization and whether or not the federal government's going to decide to impose is one of the last frontiers. One of the last frontiers of the question of federalism, separation of powers, and what can states do and what can states not do. Because if you remember back from Article 1, Section 8, it talked about the fact that Congress can negotiate with tribes. That is actually still the case. If you are a member of a tribe and you live on a reservation, and that's a whole hotbed issue, but though that's the word that we use for land that is set aside specifically for the use of particular tribes, then you can make an agreement with the federal government that you can offer gambling on your site. Best example, biggest Choctaw casino in Oklahoma. Oklahoma does not allow gambling, but on the reservation, because they have a special agreement with the federal government, it is allowed. The Texas doesn't have anything that is huge like that. Gambling, except for pari-mutuel betting and the lottery, is not legal in Texas. It's not even. Oh, and bingo. You can play bingo at bingo halls. Those are really the only three, and there are not any large tribal gaming facilities in Texas. There's 3 small tribal gaming facilities in Texas, and they don't offer anywhere near the services that like Choctaw Nation does in Oklahoma on the reservation. It does seem odd that Texas, a state that loves money, loves businesses, would say no to a large revenue source. And we'll explore at a later time why Texas is turning down that big source of money. And right now, with oil prices so low, Texas has other sources of income, but those seem to be on the downturn too. Is it time for Texas to consider? It's an interesting question. So this has been our discussion of federalism.